Welcome back to the Deep Dive, everyone. This is where we really get into the weeds, cutting through the complexity to give you the core insights you need. Today, we're tackling something absolutely fundamental in law, something that pops up everywhere from street crime to, well, massive corporate scandals. The question is, when are you on the hook, criminally speaking, for a crime someone else actually committed? We're talking about complicity, about being a party to an offense. And we're going straight to the source, Chapter 7 of the Penal Code. Our mission today, to really map out those boundaries. When does just knowing something, or maybe lending a hand, cross that line into full-blown criminal liability? And crucially, how does this apply not just to people, but to companies too? Understanding this is frankly essential if you want a solid grasp of how criminal justice works today. Now look, putting together these really deep analyses takes a lot of effort. So if you find this kind of detailed breakdown valuable, please take a second right now and hit subscribe on the channel. It genuinely helps us grow and lets us keep bringing you this level of content.
And as always, check out our website. All the curated knowledge we dig into is there for you. Okay, deep breaths. Let's get into this legal framework.
It's definitely a heavy topic, but so important because it's all about accountability, right?
Yeah.
Beyond just who physically did the act. And Chapter 7 lays it all out, starting with this core idea in Section 7.01a. Basically, it says you're criminally responsible as a party if the crime is committed by your own actions or are, and this is our focus, by someone else's actions that you are legally responsible for, or, a mix of both.
That second part, responsible for the conduct of another, that's what we're really digging into.
Exactly. And the chapter breaks it down into two main chunks. Subchapter A deals with individuals being parties to offenses, and Subchapter B tackles the responsibility of corporations and other business entities.
All right, let's start with Subchapter A then, the definition of parties to offenses. For someone maybe not steeped in legal jargon, what does being called a party actually mean in practical terms?
It means the law sees you as guilty of the main crime itself. It doesn't matter if you were the getaway driver or the mastermind who planned it from miles away. Section 7.01b makes this crystal clear. Each party can be charged with and convicted of the actual offense.
So you're not charged with helping robbery. You're charged with robbery. Full stop.
Precisely. You face the same charge, the same potential penalty as the person who, say, walked into the bank.
Now, you mentioned this is sort of a modern cleanup. The text says the law specifically abolishes all those old distinctions between accomplices and principals. Why do those labels even exist, and why get rid of them?
Yeah, that abolition is really the key shift. Historically, criminal law was obsessed with these categories. You had the principal in the first degree, the person committing the main act, then maybe a principal in the second degree, present, aiding and abetting, then accessories before the fact, helpers who weren't present, and accessories after the fact, helpers who only got involved later.
Wow, that sounds incredibly complicated.
It was. Prosecutors had to prove exactly which box someone fit into, and if they charged someone as an accomplice, but the evidence later showed they were maybe the principal, the whole case could collapse just on that technicality. It was inefficient.
So getting rid of it simplifies things.
Massively. This modern approach, which was really solidified in the early 90s based on the text, says forget the labels. Were you intentionally involved in the commission of the crime? Did you help, encourage, direct, solicit? If yes, you're a party. The focus shifts from your specific role to your connection to the crime itself. It treats everyone who intentionally participates as fundamentally culpable for the outcome.
Okay, so let's take that bank robbery example again. 3 people involved. One plans it, one drives the car, one goes inside with the weapon. Under this law,
all 3 are simply parties to the robbery. They can all be charged with robbery. The prosecution doesn't need to waste time arguing who was the principal and who was the accomplice. They just need to prove the robbery happened and that each of these 3 individuals met the legal definition of a party.
It definitely seems more straightforward and probably makes it easier to prosecute people higher up the chain, the ones who don't, get their hands dirty directly.
Exactly. The masterminds, the funders, the organizers, they're just as liable as the person carrying out the final act, provided the prosecution can prove their involvement met the party criteria.
Okay, so we understand what being a party means. Now, let's get into the nitty-gritty. Section 7.02a. This section seems to lay out the specific ways someone becomes responsible for what another person does. The actual mechanics of complicity, right?
That's right. It gives us 3 distinct scenarios, and these pretty much cover the spectrum of how you can be legally tied to someone else's criminal actions. So the first one, Section 7.02a, deals with situations where you basically use someone else as an instrument to commit the crime. The law says you're responsible if you act with the necessary criminal intent, the mens rea for the offense, and you cause or aid an innocent or non-responsible person to actually do the forbidden act.
Innocent or non-responsible person.
Right.
Well, what does that actually mean? Who fits into that category?
Yeah, it sounds a bit technical, but it breaks down fairly simply. A non-responsible person is someone who, legally speaking, can't form the required criminal intent. Think maybe someone who's legally insane, or perhaps a very young child who just doesn't understand the criminality of their actions. They might perform the physical act, but they lack the guilty mind.
Okay, like asking a 5-year-old to carry a package containing something illegal, maybe. The child does it, but has no idea what they're doing is wrong.
Exactly. The child is non-responsible. The adult who asks them, knowing it was illegal and intending the crime to happen, is the one who's criminally responsible.
And the innocent person.
That's typically someone who isn't legally incapable, but they just don't know they're involved in a crime. They might be tricked or misled. They think what they're doing is perfectly fine, but they're being manipulated by someone with criminal intent.
Do you give an example of that, maybe in a business context?
Sure. Imagine a senior manager knows they need to file a false environmental report to cover up a violation. They tell a junior employee, hey, run these numbers and file this report by 5 p.m., standard procedure. The junior employee, trusting the manager and having no reason to suspect the data is fake, prepares and files the report.
So the junior employee actually commits the act of filing the false report.
Correct. They
Wow.
perform the actus reus, the physical act, but they lack the mens rea, the criminal intent to deceive. The senior manager, however, had the intent to deceive and caused the innocent junior employee to file the report. So under this section, the senior manager is criminally responsible as a party to the offense of filing a false report. The junior employee is the innocent agent.
Makes sense. You're liable because you knowingly used someone else who lacked intent as your tool.
Precisely.
All right, scenario 2. Section 7.02. A2. It sounds like the most common type of complicity, right? The active helper, the classic accomplice or co-conspirator. What are the key elements here?
This is definitely the one we see most often. Two things are crucial. First, the mental state. The person has to act with a specific intent to promote or assist the commission of the offense. That intent is the absolute bedrock. Without it, this part of the law doesn't apply.
Okay, so intent first, and then what kind of actions trigger liability?
Once you have that intent, the actions are quite broad. The law lists soliciting, encouraging, directing, aiding, or, and this is important, attempting to aid the other person to commit the crime.
So it covers everything from, like, verbally hyping someone up to do it to giving detailed instructions to physically helping them.
Exactly. Encouragement, direction, assistance, it's all covered.
Let's focus on that attempting to aid part. That seems significant. Why is just trying to help enough even if your help failed or isn't even needed?
Because the law here is focused on your culpable mental state and your actions taken because of that state. It's punishing your decision to involve yourself, your intent to make the crime succeed. Let's say person A is going to burgle a house. Person B intends to help them by disabling the alarm system. Person B goes to the house, tries to cut the wires, but messes it up, maybe cuts the wrong wire or the alarm goes off anyway, or person A gets in and out before person B even gets there.
So person B's attempt was a total failure.
Right. But person B still acted with the intent to promote the burglary, and they took a concrete step they attempted to aid by trying to disable the alarm. Under this section, person B is still criminally responsible as a party to the burglary, even though their attempted aid was completely ineffective.
Wow. So the success of your help is irrelevant. It's the intent plus the action, even a failed action.
That's the key takeaway. The law isn't going to let you off the hook just because you were incompetent in your criminal efforts.
Okay, the third scenario, section 7.02A3, is about not doing something. Liability through omission. This is usually rare in criminal law, isn't it? Normally, you're not punished for just standing by.
That's generally true, and this section reflects that by being very narrow, very conditional. You can only be held responsible for failing to act if, first, you have a legal duty to prevent the offense from happening.
A legal duty, not just a moral feeling that you should step in.
Correct. It has to be a duty imposed by law. This could come from a statute, like a parent's duty to protect their child, or maybe a contractual duty, like a security guard hired to protect a premises, or certain professional duties.
Okay, so step one is having that legal duty. What else?
Two more things. You also have to act, or rather fail to act with the intent to promote or assist the commission of the offense. Just like in the previous scenario, the criminal intent is essential. And third, you must actually fail to make a reasonable effort to prevent it.
So, legal duty, intent to help the crime succeed by doing nothing, and actually doing nothing reasonably possible. Can you give a concrete example?
Let's use the parental duty example. Say Parent 1 sees Parent 2 about to commit felony child abuse against their child. Parent 1 has a clear legal duty to protect the child. Now, if Parent 1 simply stands by because they are terrified of Parent 2, that might not meet the intent requirement. But if Parent 1 stands by because they actively want Parent 2 to harm the child, maybe due to some twisted motive, and they intentionally make no effort to intervene, call the police, or get help when they reasonably could have, then Parent 1 could be liable as a party to the abuse committed by Parent 2.
So the reason for the inaction, the intent behind it, is critical.
Absolutely critical. It has to be inaction driven by the desire to see the crime succeed. Another quick one. Imagine a lifeguard on duty sees someone intentionally holding another person underwater. The lifeguard has a legal duty to act. If they just watch, intending for the person to drown, maybe they hate the victim, and make no reasonable effort to save them, they could be a party to homicide through this omission liability.
Got it. Duty, intent to promote by inaction, and failure to make a reasonable effort. A high bar, but definitely possible.
Okay, this next part, Section 7.02b, feels like where things get really expansive, maybe even a bit scary. This is the conspiracy liability rule. The sources call it the should-have-been anticipated rule. It sounds like you could be liable for crimes you didn't even agree to.
Yeah, this is a really significant aspect of party liability, often called Pinkerton liability in federal law, based on a famous case. It dramatically broadens the net. First, let's define conspiracy in this context. It means an agreement between two or more people to commit a felony. We're talking serious crimes here.
Okay, so it starts with an agreement to commit a felony.
Right. Now, here's the mechanism. If, during the attempt to carry out that agreed-upon felony, one of the conspirators goes off and commits another felony, a separate additional felony, then all the conspirators can be found guilty of that second felony due.
Wait, even if they didn't plan it, even if they didn't know it was going to happen, even if they were somewhere else when it happened, potentially, yes. The law can essentially transfer the intent for the second crime to everyone involved in the original conspiracy, under certain conditions. It's a form of vicarious liability, being responsible for the actions of others.
That sounds, well, incredibly harsh. If my agreement was just for, say, tax fraud, and my co-conspirator burns down the building to destroy evidence, I'm suddenly guilty of arson. There must be limits, right?
There are, and they're crucial. The law puts two very important constraints on this. If the prosecution can't prove both of these, then this expanded liability doesn't stick.
Okay, what are they?
Constraint number 1, the second felony, the unplanned one, must have been committed in furtherance of the unlawful purpose of the original conspiracy.
In furtherance of?
Yeah.
Meaning it had to be somehow connected to achieving the goal of the original plan.
Exactly. It needs a logical link. Was it done to help the original crime succeed? To help the conspirators escape? To cover up the original crime? Using your example, burning the building to destroy evidence of the tax fraud. That sounds very much like it could be in furtherance of the fraud conspiracy. But if your co-conspirator, in the middle of the tax fraud scheme, randomly decides to go assault their neighbor over a barking dog, something totally unrelated to the fraud, that's probably not in furtherance, and you wouldn't likely be liable for the assault.
Okay, that makes sense. Connected to the original plan. What's the second constraint?
Constraint number 2. The commission of that second offense must have been something that should have been anticipated as a result of carrying out the conspiracy. This is the big one, the foreseeability test.
Should have been anticipated. How on earth do you determine that? It sounds subjective. Does it mean I had to actually think it might happen?
No, not necessarily that you personally foresaw. It's more of an objective-ish standard. Would a reasonable person, in your shoes, knowing what you knew about the plan, the other conspirators, the circumstances, have seen the commission of that second crime as a reasonably foreseeable consequence, a potential risk of carrying out the original felony agreement?
So it's about predictable risk.
Pretty much. Let's flesh out that robbery scenario. Group conspires to commit armed robbery, felony 1. They all know one member, let's call him Trigger Happy Tom, always carries an illegal gun, has a short fuse, and has talked about how he won't hesitate if someone resists.
Okay, they know Tom is a potential problem.
Right. During the robbery, a security guard tries to intervene. Tom, predictably perhaps, panics and shoots the guard. Felony 2, assault or homicide. The other conspirators are outside in the car. They might even have explicitly told Tom, no shooting.
But because they knew Tom's tendencies and the inherent risks of armed robbery,
Exactly. A prosecutor would argue, and a jury could easily find, that given Tom's known volatility and the fact they were undertaking a dangerous felony like armed robbery, the possibility of someone getting shot should have been anticipated. It was a foreseeable risk they took on when they agreed to do the robbery with Tom involved.
so even if they didn't want the shooting, even if they told him not to, they could still be on the hook for the assault or homicide committed by Tom.
Yes, because it was arguably foreseeable based on the circumstances they created and participated in. This rule basically says, when you join a felony conspiracy, you're taking a gamble not just on getting caught for the planned crime, but also on the foreseeable dangerous side effects caused by your partners during the execution.
That really underscores the danger of getting involved in any kind of criminal agreement. The liability can snowball way beyond what you initially signed up for.
It's a powerful tool for prosecutors dealing with organized crime. It holds the entire group accountable for the foreseeable consequences of their collective actions.
All right, so the law defines who is a party and how liability can attach, even for unforeseen crimes in a conspiracy. Now, Section 7.03 seems to proactively shut down a couple of defenses that might seem logical to a defendant charged as a party. What can't you argue, according to this section?
Right, this section basically says, don't even try raising these two arguments because the law specifically excludes them. They highlight just how independent party liability is. The first one, Section 7.03(1), says it's no defense that, as a party, you belong to a class of people legally incapable of committing the offense by yourself in your own right.
That sounds a bit abstract. Can you give an example of where that would even come up?
Sure. Think about laws against bribery of a public official. The crime itself might be defined in a way that only a public official can be the one receiving the bribe. A private citizen can't technically commit that specific crime of receiving a bribe as a public official.
Okay, so the law targets the official.
Right. But let's say a private citizen directs, encourages, or aids that public official to commit the offense. Maybe they orchestrate the whole thing. This section says that private citizen can still be convicted as a party to the bribery, even though they personally aren't a public official and couldn't have committed the crime solo.
So your personal status doesn't shield you if you intentionally help someone else who is in the capable class commit the crime.
Exactly. Your liability comes from your role in causing or assisting the crime, not from whether you fit the definition of the primary actor. Another example, maybe simpler. If a law prohibits licensed doctors from performing a certain procedure, a nurse who intentionally assists the doctor in performing that prohibited procedure can be a party to the crime, even though the nurse isn't a doctor and couldn't violate the law directly in the same way.
Okay, the second exclusion, Section 7.032, this one feels really counterintuitive. It says it's no defense that the person whose conduct you're responsible for, the person who actually did the main act, has been acquitted or wasn't prosecuted or got convicted of something different or is immune. How can that be? If the person who supposedly committed the crime is found not guilty, doesn't that mean no crime happened? How can the helper still be guilty?
This is probably the clearest statement of how separate party liability is. It says the guilt or innocence of the person who performed the physical act is legally irrelevant to your guilt as a party.
Why? If a jury acquits the main actor, aren't they saying the prosecution didn't prove the crime?
Not necessarily. An acquittal means the prosecution failed to prove that specific person's guilt beyond a reasonable doubt. There could be many reasons for that, which have nothing to do with whether the prohibited act occurred. For instance, maybe the main actor had a valid personal defense, like they were legally insane at the time, or they acted under duress or in self-defense. That defense excuses their conduct, but it doesn't erase the fact that the act itself, say a killing, happened.
So if the shooter is acquitted on self-defense, the person who encouraged them to shoot could still be convicted?
Potentially, yes. Or maybe crucial evidence against the main actor was thrown out due to a police error, a bad search, for example. That evidence might still be admissible against you, the party. Or maybe the main actor cut a deal and testified against you. Or maybe they fled the jurisdiction and were never prosecuted. The law says none of that matters for your case. The only questions for your trial are, did the underlying offense occur? And did you act with the intent to promote or assist it? And did you solicit, encourage, direct, aid, or attempt to aid its commission? Your fate is decided based on the evidence against you, not the outcome of someone else's case.
Wow. So the state could, in theory, fail to convict the triggerman but still convict the person who supplied the gun if they prove that person supplied it, intending for it to be used in the crime.
That's precisely what this section allows. It focuses liability squarely on each individual's contribution and intent, independent of the legal fortunes of their co-participants.
That's a massive strategic advantage for prosecutors in complex cases with multiple defendants, isn't it?
Absolutely. They don't need all the dominoes to fall perfectly. They can pursue each party based on the specific evidence available against them.
Okay, let's shift gears now to Subchapter B.
Mm.
We've talked about individual responsibility. How does the law take these principles of being a party and apply them to something abstract like a corporation, an LLC, or an association? These entities don't have minds or hands in the way people do.
Right, and that's why the law first needs to establish some definitions in Section 7.21. It needs to define whose actions and whose intentions can be legally attributed to the entity itself.
So, creating a legal map from human action to corporate responsibility, what are the key terms we need?
First, there's agent, Section 7.21. So this is defined very broadly. It includes directors, officers, employees, but also any other person who is authorized to act on behalf of the corporation or association. So it could potentially include outside consultants or contractors if they're given authority.
So, agent is basically anyone empowered to act for the company.
In essence, yes. Then there's a specific term, business entity, Section 7.211A, which seems to cover things under the Business Organizations Code that aren't specifically corporations or associations or LLCs, sort of a catch-all for other organizational forms.
But the really critical one seems to be high managerial agent, or HMA. Section 7.212. This sounds like where the corporate mind is legally located, especially for serious stuff.
That's a great way to put it. The HMA is the key concept for determining when a corporation itself can be held liable, particularly for felonies. Who qualifies? The definition includes the obvious ones: partners in a partnership, officers of a corporation. But crucially, it also includes any other agent, regardless of their title, whose duties are so significant, so responsible, that their conduct can reasonably be assumed to represent the policy of the corporation or association.
So it's not just about being in the C-suite. It could be someone lower down if they have genuine policy-making authority over a certain area.
Exactly. It's the policymaker standard. If someone has the authority to set the rules, the procedures, the actual policy for a significant part of the business, maybe head of compliance, maybe a powerful regional manager setting operational standard, their actions and intentions can potentially be seen as the actions and intentions of the corporation itself, especially when we're talking about felony liability.
Okay, so agent is the hands, potentially, and HMA is the brain or the policy-making function.
That's a useful shorthand, yes.
Yes.
These definitions are the foundation for figuring out when the entity itself crosses the line.
All right, we have the definitions. Now, Section 7.22 gets to the core question. When can the entity itself, the corporation, the association, actually be convicted of a crime? The sources seem to lay out two different levels or tiers of responsibility.
That's right. The law distinguishes between general criminal responsibility, which often covers less serious offenses, and the much more serious situation of the entity being convicted of a felony. The bar is set differently for each. Let's start with the first tier, Section 7.22A. This covers the broader range of offenses. An entity can be held criminally responsible if the offense is committed by one of its agents, remember. That's broadly defined, as long as two conditions are met. One, the agent must be acting on behalf of the corporation or association. They have to be doing it, at least in part, to benefit the entity or within their role for the entity. And two, they must be acting within the scope of their office or employment.
So if a regular employee commits, say, a minor regulatory violation while doing their normal job, and it somehow benefits the company could be liable under this tier.
Yes, potentially. If the act falls within the general scope of what that employee is supposed to be doing, even if they do it in an illegal way. This tier generally applies to misdemeanors found in the Penal Code if the code says corporations can commit them. Other offenses outside the Penal Code, where the legislature clearly intended corporate liability, like many environmental or financial regulations, and strict liability offenses where intent doesn't matter.
So for these lower-level things, the action of pretty much any agent acting within their job scope can trigger corporate liability.
Correct. The idea is that the entity benefits from its agent's actions, so it should also bear the responsibility if those actions within the job scope are criminal.
But the standard changes significantly for felonies, right? Section 7.22. Why the higher bar, and what does it require?
The law raises the bar for felonies because a felony conviction against a corporation signifies a much deeper, more systemic failure. It's not just a rogue, low-level employee. It suggests something wrong at a higher level or within the corporate culture itself. So for an entity to be convicted of a felony, the prosecution has to prove that the commission of that felony was either authorized, requested, commanded, performed, or, and this is really important, recklessly tolerated by either. 1. A majority of the governing body acting for the entity, think the board of directors or the partners, or 2, a high managerial agent, HMA, remember, the policymakers acting on behalf of the entity and within the scope of their office or employment.
Okay, so for a felony, you need involvement, approval, or tolerance from the very top, the board of these HMAs. Let's talk about recklessly tolerated. That sounds like it could capture situations where the leaders didn't explicitly order the crime, but maybe look the other way.
Exactly. Recklessly tolerated is a very powerful standard. It means that the board or an HMA was aware of a substantial and unjustifiable risk that the felony was occurring or would occur. Maybe they knew that corners were being cut constantly or that illegal practices were widespread in a division, and they consciously disregarded that risk.
So willful blindness.
It's akin to that, yes. It prevents senior management from insulating the company and themselves by deliberately avoiding knowledge or by setting up systems where they can claim ignorance while illegal profits roll in. If an HMA knew, or should have known, but recklessly disregarded the risk that the felony was happening and did nothing to stop it, that tolerance can be enough to pin the felony on the corporation itself.
So the law is demanding active oversight and intervention from the top to prevent serious crime, not just passive non-involvement.
Precisely. For felony liability to attach to the entity, there needs to be that link to the policymaking or governing level, either through direct involvement or through a reckless failure to supervise and prevent.
This brings up a crucial point. Let's say the company is convicted of a felony because an HMA authorized it or recklessly tolerated it. What about the HMA themselves? Does the fact that the corporation is taking the hit somehow shield the individual human being who made the decision or look the other way?
Absolutely not. Section 7.23 makes this incredibly clear. It's often called the no-shield rule. Corporate liability does not erase individual liability.
So you can't just say, I did it for the company, so the company pays the price, not me.
Definitely not. Section 7.23A lays out direct individual liability. It states that an individual, any agent, HMA or otherwise, is criminally responsible for conduct they perform in the name of or on behalf of the corporation or association to the same extent as if they had performed it in their own name or for their own benefit. If you, as an individual, commit bribery or fraud or perjury while acting for your company, you are personally guilty of bribery, fraud, or perjury. The fact that the company might also be charged or might benefit is irrelevant to your personal criminal liability.
So both the company and the individual can be charged and convicted for the same criminal conduct.
Yes. And Section 7.23C reinforces this by saying that if an individual agent is convicted, they are subject to the sentence authorized by law for an individual fines, prison time, whatever the statute allows for that crime. The corporate penalty doesn't substitute for the individual penalty.
What about situations involving failure to act? We talked about omission liability for individuals earlier. Does that apply here too if someone's job involves a legal duty?
It does. Section 7.23B covers omission liability within the corporate context. If the law imposes a duty on the corporation or association, say, a duty to maintain safe working conditions or file accurate reports, and a specific agent has the primary responsibility within the company for discharging that duty, that agent is personally criminally liable if they intentionally or knowingly fail to perform that duty.
So if you're the chief compliance officer or the head of safety, and there's a legal requirement the company must meet, you can't just ignore it or delegate it away irresponsibly. You're personally on the hook if you fail to ensure it gets done.
That's the essence of it. The law treats the duty as if it were imposed directly on the agent with primary responsibility. You can't hide behind the corporate structure to evade a legal duty assigned to your role.
So the bottom line here is, working for a company, even a massive one, provides absolutely no immunity from personal criminal responsibility for your actions or your required inactions.
None whatsoever. The corporate veil might protect against certain civil liabilities, but it's not a shield against criminal charges.
Okay, so the potential for corporate liability is pretty broad, especially under that Tier 1 general responsibility standard. Does the law offer corporations any way out if, despite their best efforts, an agent still commits an offense? Is there a "we tried our best" defense?
There is, but it's specific. Section 7.24 provides an affirmative defense based on due diligence. But crucially, this defense is only available for offenses charged under the general responsibility provisions, basically. Tier 1 offenses like misdemeanors or regulatory violations, where liability can be triggered by any agent acting within their scope.
So this defense cannot be used if the corporation is charged with a felony.
Correct. Because remember, felony liability already requires proof of involvement or reckless tolerance by the board or an HMA. If you've got that high-level failure, claiming due diligence doesn't really make sense. The failure is the lack of due diligence at the top.
Got it. So for those lower-level Tier 1 offenses, what does the corporation have to prove to successfully use this due diligence defense? And what does affirmative defense mean in practice?
Affirmative defense means the burden of proof shifts. The prosecution proves the basic elements of the offense. Agent acted within scope, etc. Then, the corporation has the burden to prove, by a preponderance of the evidence, that it qualifies for this defense. And what they have to prove is this: that the high managerial agent who had supervisory responsibility over the specific subject matter of the offense employed due diligence to prevent its commission.
So it points back to the HMA level again. The relevant manager needs to show they were actively trying to stop this kind of thing from happening.
Precisely. It's not enough for the company to just have a policy written down somewhere. The responsible HMA needs to demonstrate they implemented real systems and controls. This could involve things like clear compliance policies, regular and effective training for employees on those policies, monitoring systems to detect potential violations, audits, and, importantly, consistent enforcement when violations were found.
So it's about showing a genuine systematic effort led from the management level to prevent that specific type of crime.
Yes. If, for example, a low-level employee dumps waste illegally, a Tier 1 offense, the company might use this defense. The HMA for environmental compliance would need to come forward and show, look, we have extensive training, strict protocols, regular audits, clear penalties for violations. We did everything reasonably possible to prevent this specific employee's action.
And if they can convince the court or jury of that,
then the corporation can be acquitted even though its agent committed the offense. It essentially rewards companies that make serious, good-faith efforts at compliance, recognizing that you can't always prevent every single instance of employee misconduct, especially in large organizations. It incentivizes proactive prevention from the top.
#tagged outro.
Wow. Okay, that was a really deep dive into a complex area. We've covered a lot of ground. From understanding that the law doesn't really care about labels like accomplice anymore. It's all about being a party.
Right, abolishing those old distinctions was key. To unpacking those 3 specific ways, you become responsible for another's actions. Using an innocent agent, intentionally helping or trying to help, or even failing to act when you have a legal duty and the wrong intent.
And then that really striking conspiracy rule, the should have been anticipated standard. That idea that joining a felony agreement makes you potentially liable for foreseeable crimes committed by your partners, even ones you didn't want. That's a heavy burden.
Absolutely. And we saw how those same principles extend into the corporate world, with different standards for general versus felony liability, hinging on the involvement or tolerance of high managerial agents, the policymakers.
And critically, that no one gets a free pass. Individuals are always responsible for their own criminal conduct, even when acting for a company. That no shield principle is fundamental.
So what's the big picture takeaway here? When you step back from all the sections and subsections,
I think the big picture is that this body of law tries to make sure criminal responsibility follows real influence and intent. It looks beyond just the physical act to see who directed it, who enabled it, who intended it to happen, or who had the power and duty to stop it but recklessly didn't. Whether it's quiet encouragement, a formal order within a company, or just intentionally looking the other way when you have a duty to act. The law tries to capture that culpability. It really shows that, legally speaking, who pulls the trigger is often less important than who aimed the gun or provided the bullets with criminal intent.
it's a powerful way to frame it.
And here's something to maybe chew on after this discussion. Remember how we talked about the acquittal of the main actor being no defense for a party? Think about the practical implications of that in the real world. If prosecutors don't actually need to convict the person who physically did the deed to convict everyone else who helped, how does that change plea bargaining dynamics? How does it affect trial strategy when you have multiple defendants? A jury doesn't have to agree on exactly who did what, just that the crime happened and each defendant on trial was legally a party to it. That procedural reality gives the prosecution immense leverage, doesn't it?
It really does. A fascinating and slightly unsettling final thought on the mechanics of justice. Thank you for guiding us through that complexity. And thank you, our listeners, for joining us on this deep dive. We hope it shed light on how legal responsibility works in these intricate situations. Keep questioning, keep learning, and we'll catch you next time.